Let's get you out of here.
Yes, ma'am.
Okay. All right, good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for July 16th, 2025. Again, all matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll go ahead and call our next case. It is 2021 DCV 1635 Gerardo Garcia and Columbarium by Design LLC versus Fernie R. Aceves. May I have announcements, please?
Good morning, Your Honor. James Fuel on behalf of the plaintiffs.
Lisa Hayes for the defendant, Fernie Aceves, we're ready.
And for purposes of the record, yes, we are conducting the proceedings over Zoom. Sorry, I'm reading and speaking. We are set for trial, docket call. We're set for trial on Friday to select a jury and proceed with evidence on Monday. As I was alluding to maybe at our last hearing, I was going to try and figure out a way because you all had announced ready to make sure that we could, the court could go forward. I was able to secure a visiting judge for your trial, as well as basically everything is going to happen in the 41st. It won't be Judge Ana Perez, it will be Judge Kitty Shield. And you all have a panel, I believe, of 60 jurors, Mr. Nanez, yes. So with that, what do you all have for the court?
Well, Judge, as I alluded to when I logged on early, I was planning on speaking to Ms. Hayes about this, but I wasn't able to. The parties have, frankly, finally been talking about settlement over the last 2 weeks. We did mediate this case, I think, 18 months ago, but frankly, we weren't really in a position to do so. If you recall, the first trial setting on this matter, I was substitute counsel. I had stepped in late, and there were discovery issues. And so when that first mediation happened, I don't think either of us had the documents that the other side had. And we're finally working towards settlement, but we're not there. And I think it would really benefit my client to be ordered to mediate again. And I haven't spoken to Ms. Hayes about that, so I'm surprising her right now, and I'm surprising you. And I know that this might be frustrating to you since you've spent the last 2 weeks trying to work on a second judge. So forgive me for that, but I do think it'd be beneficial for my client, Judge. And I apologize to both you and Ms. Hayes for doing this now, but I think it would be helpful.
Ms. Hayes?
I frankly cannot disagree with anything that Mr. Fuel said. In terms of the first mediation, he is correct that we both went to mediation with incomplete files. Neither one of us aware of that. Mr. Fuel thought that there had been production by prior counsel of, quite frankly, the volume of this case. And it had not been produced. And we didn't realize that until December, when we were before Your Honor again, getting ready to go to trial. And we had done our motions in limine, and we're talking about our charge. And I saw some language in the potential charge that caused me to wonder if I had all of the information. And at that moment, we realized that the reason why the charge seemed unfamiliar to me was because I had never been produced that information. And Mr. Fuel believed that I had been. And so I probably received at that time maybe 2,000 pages of records that I had not seen before. And I've been working diligently on it. And it has resulted in some productive conversations with our respective clients about settlement. But they're very recent, quite frankly. And I guess only secondarily, but probably equally important, I have not discussed with my client the possibility of Judge Shield being appointed and whether or not that would be something that he would object to. I think that we ought to have that opportunity as well to speak to our clients about that.
Yeah, well, so I'm hearing about why the December 2024 jury trial was passed over, right? Because that's when you all become aware we get a new scheduling order in January.
Yes, ma'am.
So the deadline, with all of that in mind, the deadline to mediate was June 17th, and it didn't happen. And so that's a little bit of my frustration
I
because
understand.
now, I heard 2 weeks ago that you all were ready to go to trial, and now that's changing. Well, actually, Ms. Hayes was going to be unavailable. And it didn't happen, and this is a very old case. I can't cry too much because there's so many jury trial settings in this case. I got to think one of them is on the court. But in any event, it doesn't sound like I might be hearing the same thing if we had pushed it to trial sooner. You're going to have your order to mediate within 60 days. Do you have an agreed to mediator?
Well,
Yes.
because I didn't get to speak to Ms. Hayes, but I think we can agree to a mediator. I don't think that's a problem.
Not a
Okay.
problem.
The order will come out. Carlos Cardenas will be the default if you all cannot agree. Okay?
Yes, ma'am.
Understood.
So we need to cancel, Mr. Nunez. We need to cancel the jury. We need to let COJ know. We need to let Judge Shield know.
And
And
Judge, I really do apologize. I know the court worked hard to get a second.
No worries.
It's
No worries.
I'm frustrated too, frankly, with myself.
We're going to have a final civil pretrial. If we're talking about 60 days from today to get the mediation done, give me a second. We're going to come back on October 1st for a final civil pretrial. Okay?
Yes,
Yes.
ma'am. Yes,
Yes,
ma'am.
Judge.
Or entry of judgment, whatever. What?
Yes,
Was
Judge.
somebody else saying something? No? Okay. All right. So let's cancel that out, Mr. Nunez. Thank you very much. You all are excused.
Thank you, Your Honor.
Have a good day.
Jimmy, I'll call you right now.
Yes, ma'am.
I'll give you a minute, Mr. Nunez, if you need to identify some folks.
Yes, ma'am. Thank you. Hello, Samsung user. Who is this? Hello, Samsung user. Hello? Who is this? Hello? Samsung user.
Hello,
Hello.
mi nombre es Víctor Reyes.
I'm sorry?
Mi nombre es Víctor Reyes,
¿Y por qué está aquí, señor?
porque tengo una cita ahorita a las 10 con la jueza
He's on page 3.
Alicia Pérez.
Ok, señor. Lo voy a poner en la sala de espera hasta cuando le hablemos, ¿ok?
Está bien.
No se
Gracias.
vaya.
Is Juan Uraga still on that case?
Ya no.
Albert Beal, I believe, Judge?
Mr. Ormiston, any luck with Mr. Grajeda?
No, Your Honor, I have not heard anything back from him.
Okay. So on that one, Mr. Nunez, on page 5, 3531, what you can anticipate, Mr. Ormiston, is that I will set you 60 days, 45 days out for a dismissal hearing in the event we don't get the documents, the dismissals. If we do, obviously that hearing will go away.
Okay, perfect, Your Honor.
Thank you. Thank you for
All right.
waiting.
Oh yeah, no problem. Thank you. Appreciate it.
Mr. Nanez, I believe Attorney Moyer is here on the motion to dismiss on page 4, as is Mr. Baeza. So I see that we're still missing a lot of folks, so we're going to start there because that's going to take a minute.
On which one, Judge? I'm sorry.
Page 4, Valerie Sepulveda.
Yes, ma'am.
Shannon Schmoyer, are you there? If you would, please turn on your video. Good afternoon, ma'am. I mean, good
Thank you,
morning.
Your Honor.
Oh God, it already feels like afternoon.
Your Honor, just my co-counsel, Michael Ritter, he just appeared, which I'm very glad about because he's doing the argument.
Okay, well,
I'm very
good.
glad he's here.
Your name was on the docket, so that's why I called you. But I've
Thank
been
you.
telling a few folks we're going to have a lot of substantive long hearings this morning. So if you all are ready, I'd like to go ahead and get started. Yes. Okay.
Yeah.
This is cause number 2024 DCV 0587, Valerie Sepulveda versus Robert Alvarez, Walgreens Company doing business as Walgreens store number 11516. May I have a now?
Good morning, Your Honor. Jonathan Baeza on behalf of Plaintiff Valerie Sepulveda.
Good morning, Your Honor. Michael Ritter on behalf of defendants Robert Alvarez and Walgreens Company.
Are you going to announce Ms. Schmoyer? Ms. Schmoyer is also here, but I understand, Mr. Ritter, you're going to handle this motion. We are set for defendant's motion to dismiss. I do see plaintiffs have filed a response. Mr. Ritter, you may proceed.
Permission to share my screen?
You may.
Is everyone able to see?
Yes, sir.
Just to start off with a brief background of the facts here. This is a sexual harassment, primarily lawsuit filed by Ms. Sepulveda. Ms. Sepulveda worked for Walgreens, and she alleges that she was a junior pharmacy technician and that her senior pharmacy tech, Danny Morales, sexually harassed her, told her that her butt was big. She could see her underwear, her thong when she bent over, and constantly stared at her. Sepulveda reported this to her store manager, Sonia Wilgus, and then defendant, Robert Alvarez. She alleges they didn't take any prompt remedial action for some period of time. However, the allegations in the complaint don't state how long the sexual harassment lasted or how long the period of time was for the failure to take any action by defendant Alvarez. At some point thereafter, according to Ms. Sepulveda's allegations, loss prevention employee Cielo Burmeyer was investigating the report of sexual harassment. There's not a lot of allegations in the complaint itself, but at some point thereafter, there was a meeting where Burmeyer asked questions about sexual harassment and Ms. Sepulveda about time theft. Ms. Sepulveda was thereafter discharged for the time issues. So today we have a lawsuit before the court where Ms. Sepulveda has sued Walgreens as her employer for wrongful termination and sex discrimination, as well as sexual harassment. In addition to Walgreens, Ms. Sepulveda has also named the district manager, Robert Alvarez, as a defendant and suing him for being responsible for sexual harassment. Specifically under a new provision of the Chapter 21 of the Texas Labor Code, subchapter C1. The case was removed to federal court, and then after some proceedings, the case has been remanded to this court for further proceedings. And that brings us to today's motion, which is a Rule 91A motion to dismiss. And the primary issue for the court's resolution is the subchapter C1 sexual harassment claim.
Okay, did we lose Mr. Ritter?
His screen is still up.
I see that, but I don't see him.
Yeah.
Ms. Schmoyer, are you able to reach out to him? I don't know exactly what's happening.
Yes, Your Honor.
Thank you. While we're waiting, off the record, Mr. Grajeda, are you still there? Mr. Grajeda, opposing counsel did appear earlier and indicated that you all were filing cross dismissals. So I'm resetting for a dismissal hearing in 45 days unless we get those documents, okay?
Okay, Judge, that's perfect. Thank you.
Thank you very much. Bye-bye.
Bye-bye.
Folks that are here on the okay, there's Mr. Ritter. Folks that are here on the Cabral case, we'll be with you shortly, okay? All right, Mr. Ritter, we lost you. So I don't know if you need to reshare your screen. We can
Oh, yes.
try that again.
Thank you, Your Honor. So the primary issue is whether or not Mr. Alvarez is an employer under Chapter 21 sexual harassment provisions that were added to Chapter 21 by the Texas legislature in 2021. So Chapter 21 is the state level version of Title VII, protects against discrimination on the basis of race, sex, national origin, etc. in employment. The general rule under Chapter 21 is that Chapter 21 is intended to enforce Title VII. Under both Chapter 21 and Title VII, the general rule has always been that the institutional employer is the only proper defendant for discrimination and sexual harassment suits. So if you supervise an employee, you individually, when you go home, when you're off the clock, you are not that employee's employer. Only the institutional employer is. Chapter 21 globally defines employer as having 15 or more employees, and that's the same threshold for Title VII claims. In 2021, the Texas legislature addressed the problem of sexual harassment victims who worked for employers who had 14 or less employees. They had no remedy under Title VII or under Chapter 21 for sexual harassment. So what the legislature did in 2021 was they wanted to expand protections for more employees who were victims of sexual harassment and make it easier for them to have access to courts. The legislature did this in two ways. The first was expanding the exhaustion period, the timeline to file a charge of discrimination with the Workforce Commission, to 300 days, up from 180. The second was the addition of subchapter C1 sexual harassment claims, where employer is specifically defined for sexual harassment claims as someone who employs one or more employees. So the statutory construction issue we're asking the court to decide is this. By defining employer in subchapter C1 as one who employs one or more employees, did the legislature intend to deviate from Title VII for the very first time and create supervisory liability? Or did the legislature merely intend to eliminate the 15 employee minimum for sexual harassment claims? One of the big issues with this particular statutory construction issue is that there is inconsistencies between how administrative agencies are handling this issue and the rulings that we're getting from federal district courts who are predicting how Texas courts would rule. So as per Ms. Sepulveda's response, she actually lays this out, really highlighting the problem, is that the forms that are used for the EEOC and Workforce Commission, because they're based on Title VII and Chapter 21's principle that individuals are not employers, are that it requires naming only the institutional employer in the charge. So as a result of that, the addition of individual supervisors as defendants, they're not being notified like other employers are, like they should be if they really are considered employers. So what's happening is that the agencies are not interpreting subchapter C1 as including liability for individual supervisors. The problem there is that we're seeing a conflict with how federal district courts are predicting how Texas courts would rule whenever a case is removed to federal court for diversity jurisdiction purposes. So as per the briefing, there's been several decisions by U.S. district courts as to subchapter C1 on this issue. The very first case was Brown-Steffes out of the Northern District, I believe it was Dallas, where the district court's opinion assumed without deciding that individuals could be sued under subchapter C1, but then concluded that even if the suit was proper, the charge was not timely filed. The second case, which is a bigger case, is Quinones versus Perez out of the Western District in El Paso, where the employer and the employee agreed that subchapter C1 applied to supervisors. Pursuant to that agreement, they also agreed that the FMLA, which is the Family Medical Leave Act, and the Fair Labor Standards Act, which are federal laws regarding wage and leave, that there is a test for individual supervisory liability. So using that framework, other courts, such as Siegel and Morgan, have said, well, Quinones has applied the standards, so we're going to as well. That's what happened in this case when the defendants removed this proceeding to federal court. And I wanted to just highlight some issues from that decisions for the court to contextualize where we're currently at. So these issues, when raised in federal court, aren't raised as dismissal issues. They're raised as questions of federal court jurisdiction, specifically under the fraudulent joinder doctrine, whenever there's multiple defendants, one of which who is added, the addition of that defendant destroys diversity jurisdiction of the federal court. In this case, federal district court cited Quinones, where the employer and employee had agreed that the FMLA and FLA framework apply without discussion of the arguments that were presented under the state law statutory construction issues. Those issues are being presented today for the court to decide, because when it comes to matters of state law, state courts have the final say interpreting what state law means, which is why federal courts sometimes will certify a state law question to the Texas Supreme Court to ask the Supreme Court, what is your interpretation of the statute? And so in this context, it's one of the rare instances in which the state court's law controls over what the federal courts would say. And so it kind of flips the script a little bit with regard to who the final decision maker is. Unfortunately, Texas courts, after 4 years of subchapter C1 being in effect, have not provided any guidance on this issue. Recently in 2024, the Supreme Court flagged the issue as we're not going to decide this case here, or this issue here, because we don't need to. And more recently, the San Antonio Court of Appeals did the same in base. So what we have is this conflict between administrative agencies, how federal district courts are predicting Texas courts would rule, but Texas courts not actually providing an answer. The Rule 91A motion here, the main position is that Defendant Alvarez is not a subchapter C1 employer based on state law principles of statutory construction. What the court is seeing here is the global definition of employer for Chapter 21 general. So this is the same one that models Title VII, where individual supervisors and individual employees are not considered employers who are proper defendants. The subpart 8B is highlighted for the court because when reading this definition, one could reasonably conclude that employer means not only a person or a company who employs 15 or more employees, but also an agent of that person, described by paragraph A. There was some debate in the litigation over this interpretation, and Texas courts have unanimously held that this global definition of employer does not create individual liability, even though it says an employer could also be an agent, i.e. an employee or supervisor of an institutional employer. The reason why courts have held this is because the purposes of Chapter 21 are to provide for the execution of the policies of Title VII, and as a result, globally, so for Ms. Sepulveda's wrongful termination claim, for example, not a sexual harassment claim, but a wrongful termination claim, is undisputed that Mr. Alvarez is not her employer. Mr. Alvarez cannot be sued for wrongful termination based on sex discrimination. The question is whether the definition of employer for sexual harassment claims added in 2021 intended to deviate from Title VII's general rule, the longstanding principle in Texas that individual supervisors are not proper defendants for these types of claims. Like the global definition of employer for Chapter 21, Subchapter C uses the same two-part test. Employer means a person who employs one or more employees or acts directly in the interest of an employer in relation to the employee. Notably, subpart 1B defines employer with the word employer. So if we're trying to determine what does employer mean in 1B, because it uses a word to define itself, we have a couple of options to consider. One is a definition that's provided right here, which results in a circular reference, or refers back to what Texas courts have held unanimously with regard to Chapter 21's global definition, is that it's referring to someone who is acting in the interest of an employer, which could be an agent, but it also could be someone who doesn't work for the company, who is a sexual harasser, such as a vendor who comes in. Notably, in passing the amendments to Chapter 21 in 2021, the legislature did not change or expand the purposes of Chapter 21. And so the argument that Ms. Sepulveda is making, that Mr. Alvarez is her employer under 1B, is based on the same type of reasoning that Texas courts have rejected as to the overall definition of employer in Chapter 21. What's really notable about the 2021 amendments is the context and the legislative history. So the decision as to whether or not to permit individual supervisors, that means anybody in the state of Texas who supervises another individual, can for the very first time be sued for Chapter 21 sexual harassment claims. Looking at the legislative history, everything indicates that the goal was to expand the category of plaintiffs who could bring claims. The idea was there are employers with 14 or less employees, and if somebody is subject to sexual harassment, they have no remedy. There's no indication in the legislative history that Texas decided to tackle a very significant public policy change that a lot of the states disagree on. There's splits among the states as to whether or not to recognize individual liability for these types of claims. What federal courts have eventually ruled under the Quinones case and subsequent decisions is that instead of looking to Title VII for an analysis as to whether an individual supervisor is also a separate employer, it's called the economics realities test. So in Quinones, the employer and employee agreed to use that framework. And the reason why is because the FLSA definition of employer looks quite a bit like subchapter C1's 1B language. However, there are a couple of distinctions between the FLSA language and the Chapter 21 language, which indicates that the legislature did not intend to wholesale adopt the FLSA standards for what an employer is under that federal statute. So under the economic reality test, there are 4 factors as to determine whether or not a supervisor is an employer who can be sued individually. Can they hire and fire the person? What is the degree of supervision or control over schedules and conditions and wages? The method of pay, and 4th, and who maintains the employment records. The district court in Quinones recognized that 2 of the factors out of the 4 are of dubious applicability for discrimination claims. And what that means is essentially that it's not really a good fit for interpreting whether or not an individual supervisor is a employer under a sexual harassment type claim. And the reason why is because the realities of sexual harassment claims are fundamentally different from wage claims or leave claims. And here's kind of a hypothetical to illustrate that. So many companies have developed policies that if there is sexual harassment, that the employee can report it to human resources or their supervisor. But a lot of the times, the policy requires human resources or some other entity to conduct an investigation to determine what happened. So suppose you're a high-level supervisor. One of your employees comes to you and says that they've reported to their supervisor that they're being sexually harassed. And you consult your company's policy, and it says that you should direct the employee to human resources to conduct an investigation to determine what happened so that they can report to you so that you can take appropriate remedial action based on those findings. But suppose human resources doesn't take prompt action to investigate. Because there's no investigation, you've directed the employee to human resources. The question is, did the Texas legislature intend that you could be sued personally in this situation when human resources wouldn't be an employer and a proper defendant? The immediate supervisor wouldn't be a proper defendant, and the sexual harasser themselves would not be a proper defendant. This issue is only compounded, the problem is only compounded by the fact that administrative agencies, Workforce Commission, and the EEOC are not notifying individuals of these charges that are coming through to give them a heads up and an opportunity to address and correct the issue. So based on all of this, we are seeking dismissal of Mr. Alvarez from this suit for the sexual harassment claim only. This does not affect Ms. Sepulveda's wrongful termination claim for sex discrimination or her sexual harassment claim against Walgreens based on this particular issue of Alvarez not being an employer. In essence, we're just requesting a ruling from a Texas court, which has the final say on what state law means in this context as to whether or not individual supervisors can be employers under subchapter C1. There are a few other issues just to address briefly for the court. 2 other issues raised in the motion, one of which I referred to already, which is that there are no dates to determine whether or not Alvarez failed to take prompt remedial action to start the investigation. It could have been 3 days, or it could have been 3 years. We also do not know how long Morales' conduct lasts. That's the alleged sexual harasser, whether this incident occurred over the course of 3 days or 3 years. And so in sexual harassment claims, when you look at the overall totality of the circumstances to determine the frequency or severity of the alleged harassment, it does not rise to the level of a cognizable sexual harassment claim. There's also some briefing on administrative exhaustion, but that is primarily to highlight the challenge that is being faced by individual supervisors who are being brought into court without any notice from the EEOC or the Workforce Commission, and without giving those defendants an opportunity, and the EEOC and the Workforce Commission the opportunity to conciliate and settle these issues before they even get to court. In our response, Ms. Sepulveda has asked for sanctions to be awarded, attorney's fees into Civic, and we're asking the court to either deny or defer on that request. Ms. Sepulveda has not alleged that this motion has been brought for delay or bad faith purposes. The U.S. District Court ruled as much when it denied fees. The issue being presented here is a different issue than what the district court decided. As mentioned before, federal court jurisdiction, diversity jurisdiction, improper joinder, those are all separate issues that have to deal with federal court jurisdiction and aren't presented today. Federal courts are predicting how Texas courts would rule. They're not deciding what Texas law is. In this particular case, the district court's remand decision didn't actually address the statutory construction issues that we're presenting for the court today. And so none of these arguments have really been ruled on by any federal district court. And we're seeking a ruling from a Texas court on this matter to help resolve this situation. Alternatively, we ask the court to defer on the request for attorney's fees because it's undisputed that if Ms. Sepulveda prevails on our sexual harassment claims, she's entitled to mandatory attorney's fees for the entire case, which would include these proceedings. And at this time, defendants are not seeking attorney's fees either. And the very last issue is the Rule 91A timeline of requesting a ruling within 45 days of the filing of the motion. Very short timeline on these Rule 91A motions, but wanted to advise the court of that deadline.
Thank you, Mr. Ritter. Mr. Baeza?
Yes, Your Honor. Thank you.
Mr. Ritter, can I ask you to stop sharing your screen in case Mr. Baeza wants to share something? Thank you, though. All right. Yes, Mr. Baeza.
All right. Thank you, Judge. Keeping it simple. The question here is really, did the legislator mean person when it said in the new law, person? That's the question. When it said person, did it mean person or did it mean a corporation? So first, let me go over the legal standard of the 91A because defendant seems to be basing the motion to dismiss and plaintiff's pleadings on a heightened standard. Texas is a fair notice state. And clearly, based on the PowerPoint, based on the motion to dismiss, defendant knows exactly what the claims are here. They know exactly what the allegations are. So fair notice is met. But under Rule 91A, the question is that can a reasonable person believe the facts as pleaded? Can a reasonable person believe the facts as pleaded? And a court considers allegations of the live petition, the original petition that we have here, and all of the allegations are taken as true with inferences reasonably drawn from them in favor of denying dismissal. So that's how we have to look at this. We have to look at this with a fair notice standard and taking all the allegations in the petition as true. So moving on, I'd like to talk a little bit. This is a very important issue, Your Honor. This is a new law. This is sexual harassment law. The Biden administration also made some changes after Texas brought this new law. Biden administration decided to follow suit and said no more arbitration for sexual harassment claims. And that's part of a bigger public policy problem in the United States when it comes to sexual harassment. So today, what defendant and Walgreens asks you to do, Judge, is to is to hold that Alvarez, or the new law, when it says person, does not mean person, and disagree with the findings of Judge Cardone of the Western District, Judge Briones of the Western District, and judges out of the Northern and Southern District. They also ask you to disagree with the Texas Pattern Jury Charge 107.21, which was amended in 2022, which says in a note, individuals may be liable. This is regarding sexual harassment claims. Individual may be liable, and concluding that supervisors, managers, human resources professionals, and coworkers may be named individually as defendants in an employee sexual harassment complaint and be held personally liable for failing to address alleged sexual harassment. That's the pattern jury charge. They also ask you to disagree with them. They also ask you to disagree with their own colleague, Mr. Harrison Smith, in 2022, who was a part of Counsel Ritter and Schmoyer's firm, when in a conference, he said, by the way, the new 21, 141, and 142 broadens the definition of who qualifies as an employer and establishes a heightened standard for sexual harassment. And it includes potential liability to individuals. They also ask you to disagree with many of the other individuals, including Mr. Gilbert Sanchez of our own El Paso bar, in a conference, who said the same thing. Everyone that interprets this says the same thing. When legislators said person and employer means a person, that's exactly what they meant, a person. And defendant here is wrong to assert that the legislative intent was just to include those victims that are employees of small employers. Because if they wanted to do that, logically, all the legislator had to do was change the number. And they did that, where they said in the new law, 1 to 14 employees, you can file too. But the legislator went beyond that, and they added this new definition of employer. If they wanted the old definition, as Walgreens wants here, they could have left that definition alone, but they didn't. And they also went on, because this is part of the briefing, to change the definition of sexual harassment itself. Not the old definition of severe and pervasive, but a new broadened definition. So to sum it up in regards to legislative intent and the new law, which took effect in September 1 of 2021, broadened the definition of employer. Now it's not just 15 or more employees, Title VII still is, but under Texas law, it's 1 to whatever. Infinity employees are now included in this. That's small businesses, medium businesses, big businesses. It also included new individual liability, wherein it said employer means person. It lowered the threshold for employer liability, because it says employers are now liable if they knew or should have known about harassment and failed to take immediate and appropriate action. That has nothing to do with small versus large employers. That's the bigger problem of sexual harassment. There's a stricter duty. It extended the statute of limitations for filing a claim for Texas cases. It used to be 180, now it's 300. That has nothing to do with small versus large employers, as defendant asserted. So here, Your Honor, while it's true that historically Texas did not allow for individual liability in sexual harassment cases, our legislator recognized the need for stronger protections and greater accountability. This is why the law was changed. The new language adds all these things. Now, large corporations like Walgreens, they may oppose the expansion of individual liability under this new updated law because it introduces a new level of accountability. And that's exactly what they don't want. They don't want accountability in their own corporation when it comes to sexual harassment. This new law directly impacts their management and supervisory staff, and it encourages higher standards of conduct. That was the intent. And it ensures that those in leadership positions, supervisors, manager, HR, they take these harassment complaints and workplace culture more seriously. That was the intent. Now, corporations don't want this. They wanted to remain the status quo. That's what they're arguing for today. the status quo. But if the purpose was the status quo, the law never would have been changed. So the facts are what the facts are. There's a complaint. There's fair notice. The defendants urge the court to ignore the plain text and the ample authority of Texas Labor Code 21-141. And Your Honor, there's defendant had it on the PowerPoint. There's just in our brief alone, we point to Western District 2 cases. This case, these specific facts. And I disagree when defendant says Judge Briones did not speak to the issues. No, he directly held, and there's a quote in our brief that specifically says, where Judge Briones says, interpreting Texas law and utilizing the economics reality test as Judge Cardone did, as other judges have done, he believes there's sufficient evidence and a reasonable person could find that Alvarez is an employer. When it says employer means person, Alvarez is a person. He's a person that acted as an agent. He knew about the sexual harassment and he did nothing. Briones has already held on that. Your Honor, in regards to the argument that the agency's EEOC is not interpreting this new Texas law as individual liability, there's nothing to support that. The EEOC, I practiced in New Mexico as well, and New Mexico is one of 8 states that allows for individual liability in employment lawsuits. When you file with New Mexico through the EEOC, you have to put it in the body. You have to specify, as we did here, that you're also alleging individual violations. Now, that the EEOC has never come out and said, hey, we're interpreting TECRA to not include individuals. That's not true. That's never been said. There's a dual filing. We file the dual filing. We put everything we can in the facts. And in our EEOC charge, there's a specific paragraph, the last paragraph, that says we intend to bring this claim individually against, and it names the individuals, including defendant Alvarez. And it says, EEOC, we ask that you send all these individuals, including Walgreens, a copy of this charge. And Judge Curita years ago had a good finding on the allegation or the claim by a defendant that the administrative remedies of the EEOC weren't exhausted. And she said, the only duty of an employee, a plaintiff, is to dual file the claim with the EEOC, include all the facts possible, and anything that can reasonably and objectively come out of those facts, the particulars in the charge, that's what you can file a lawsuit on. And then Judge Curita specifically said, if the EEOC or the TWC fails at their job, notifying someone, EEOC notifying TWC or TWC notifying EEOC, that is not held against the plaintiff. They did what they needed to do. The same is here. Ms. Sepulveda did what she had to do. And there's plenty of briefing in our brief pages. Starting up with page 7, it goes through the factors, Your Honor, that Judge Briones had to go through on whether Alvarez, under the economics reality test, should be considered an employer. And we agree, and Judge Briones agreed with with that the facts lay out that the factors support and weigh in favor under TECRA, finding that Alvarez can be held individually liable as an employer. Specifically, Judge Briones says, for all the reasons stated above, the court is of the opinion that defendant Alvarez is an employer under section 21-141 of the Texas Labor Code. We believe that here, Judge, in our Texas courts, the plain meaning of person should mean person, and it does mean person. And while defendant brings this legal jujitsu of circular argument, person means person. And if legislator wanted to stick to the old definition, they could have done that. but they chose not to do that. And the majority of people that, individuals in the law that have looked at this have held that a person means an individual like Mr. Alvarez. One of the arguments defendant brought was that because Ms. Sepulveda has not brought forth enough evidence at this point to show that the harassment by Morales was severe and pervasive, then this case should be dismissed. Again, they go back to the old law. They admit in their brief that the new law isn't severe and pervasive, but specifically that the law was changed to broaden the definition of harassment. And under that broadened definition of harassment, this is page 13 of plaintiff's brief. Under that broadened definition of harassment, we've pled fair notice. We're at the 91A stage. We're at a motion to dismiss right now. The pleadings provide fair notice to defendant of what the allegations are. That is that sexual harassment occurred under the new law. That means that Alvarez had knowledge and he did nothing. The new argument that defendant has brought that they did not bring in or that they reserved in federal court is that of failure to exhaust administrative remedies against Alvarez. And that's part of the Judge Gurita's finding. Here specifically, we included that in our petition, a specific allegation that we exhausted all administrative remedies. You see that in the EEOC charge that defendant added to their motion to dismiss. And just practically, whether it's New Mexico or Texas, defendant wants plaintiff to pay for the fact that you can't put Alvarez on the form under employer. You just can't. They won't allow it. They will not accept it. So you put it in the particulars and you state exactly what you're doing. And defendant wants to say that plaintiff Sepulveda did not exhaust administrative remedies. There's no law that says that. And Judge Gurita in the Bali decision said that that's not plaintiff's fault. And in regards to the attorney's fees, the reason we believe we're entitled to attorney's fees, Your Honor, is because this issue was settled. We filed in state court. If they truly wanted a state judge to determine whether Alvarez was an employer or not, they could have asked you in the beginning. But instead, Walgreens went forum shopping, went to a federal court who they hoped would be favorable to the employer. And when Judge Briones ruled against them, sends it back down, remands it to state court. Now they want to bring it up again and say, whoa, those issues weren't decided. Yes, they were, Judge. If the purpose was truly so that a state court could decide, this would have been in your hands in 2024, because that's when this was filed. But instead, they went forum shopping, they lost, and they're trying to take a second bite of the apple. And because of their second bite of the apple, plaintiff has had to exhaust time and effort in order to respond to the old arguments and the new arguments. And that's why we believe we're entitled to attorney's fees, Your Honor. If you don't have any questions for me, I'll reserve any other argument.
I do not. Mr. Ritter, I'm going to ask if you have just a brief response, please.
3 quick points in reply. Walgreens removed this case to the Western District of Texas to have, because it decided the Canonius case, to develop the reasoning or to address our particular statutory construction arguments that have never been addressed by any federal district court before. And what's happening is that the district courts are no longer considering statutory construction arguments. They're going with Canonius, where the employer and employee agreed in that case to apply the FMLA and FLA test. So contrary to Mr. Baez's position that we're forum shopping, we were seeking a development of the case law to get an answer as to our statutory construction arguments. However, the decision from the district court did not actually address those arguments. The second position, or second point in response is to Mr. Baez's overall main point. Person means person. But that's precisely how the Texas legislature defined person for Chapter 21 globally. For all Chapter 21 claims, an employer is a person. Globally, It's a person who employs 15 or more employees and even an agent of that person. In subchapter C1, the Texas legislature defined employer for sexual harassment purposes using the exact same word, person. Mr. Baez's point is that the legislature indicated that it meant a different thing by person. But a person is a person under Chapter 21, and the legislature didn't redefine what a person is. They went with the purpose of Chapter 21, which is to enforce Title VII, for which there is no individual liability. So person does not mean individual supervisor for Chapter 21 generally. And so if the legislature wanted to make a change, they would have specifically stated individual supervisors could be liable, and they did not. The third point is that Mr. Baez had indicated a lot of secondary resources like commentators, PJC, were asking you to disagree with them. And what happened, Your Honor, was that there was a lot of discussion when this new law was created as to whether this would create individual liability, because the definition included in sexual harassment in C1 resembles the FLSA text, which was previously shown to the court. But there are material distinctions between the two, which establishes the legislature did not intend to wholesale adopt the FMLA FLSA standards, which the federal courts have said, this test doesn't really make much sense here. So with all of that, we're asking that the court grant the motion to dismiss Alvarez from this suit for purposes of a sexual harassment claim under subchapter C1.
All right, counsel, thank you very much, and thank you for the extensive briefing on this. The court is going to take a minute to review certainly both of the pleadings in light of your arguments today. I don't anticipate that I will take, my goal is to have that back to you by the end of the week, but I'd say give me a week. I hope that, I think that keeps us within any type of deadline. What I don't have scheduled today, and I don't know, frankly, if we've ever had scheduled a scheduling status conference, so we can maybe get overall. Are you all able? Can we just do that now, so I don't have to set you 30 days down the road, and then we get further down into 2026? Are you all okay with that, Ms. Schmoyer, Mr. Baeza?
Yes, Your Honor.
Ms. Hernandez, what maybe about I'm going to say a year out. A trial date, a civil trial date, about a year from now. What date do we have?
Judge, I have July 24th, 2026 set for the civil docket.
Okay, that'll be your trial date. The docket call will be the Wednesday before that, so that's July 22nd, 2026. We'll send you all the proposed scheduling order. Feel free, if you all want to work off of that and create your own, just make sure that you include your agreed to mediator. Anything outside of those dates, please request your hearing via email and your filed pleading with Ms. Hernandez, and we will get you scheduled outside of those dates. For my purposes, I'm just going to ask Myrna that you put a notation. What are we, Wednesday? A week from today. On this case, it's not for the parties to appear, but just to make sure that I have a ruling for you all, okay?
Yes, ma'am.
Yeah, 2 weeks from now, you'll have your entry on that scheduling order. So if you return it to the court, you do not have to appear for that either. Okay?
Thank you, Your Honor.
Thank you, Judge.
Thank you for your time and your arguments. Have a good day. Mr. Baez, I feel like you have something else on the docket, so I'm not going to say you can go, but maybe check your calendar. Thank you, Ms. Schmoyer. Thank you, Mr. Ritter.
Thank you, Your Honor.
I have my Cabral attorneys, please. Because we have, again, a very, very packed docket today.
Good morning, Your Honor.
Good morning, everyone. So if memory serves, and I apologize, we had a substitute coordinator. I thought we had said 9 o'clock because I wanted to give you guys a little extra time on the docket today, but it didn't make the docket as 9 o'clock. So we're here as 10 o'clock. And I still see a motion to compel on the docket. And I didn't, in the list of either in the amended notice, hearing notice, or the email I got of pending motions or things that we need to hear in the next 2 days, I didn't see a motion to compel, so maybe you all can enlighten me on that. in the interim, though, I'm going to call the case. This is 2022 DCB 0886 Eduardo Cabral et al. Versus RV Sharon Landstar Ranger Inc. May I have announcements?
Good morning, Your Honor. Brendan Villanueva here on behalf of the plaintiffs, and I'm along with Kevin Lyles and Stuart White and our co-counsel with Beck Red and Nicholas Bruno. We're all here for the plaintiffs.
Good morning.
Your Honor, Carlos Rincon and Jeanette Garcia from Rincon Law Group. I have Roberta Guido and Richie Costa as their paralegals of their firm, and Brian Casey with Right Close Barger. We're here on behalf of Landstar Ranger.
Okay, and so we are set for docket call today. As I indicated last week, knowing that there were still several moving parts outstanding, I guess, we have scheduled, it was listed on Thursday as a docket call, and I think that's why we had some of the confusion, maybe in emails. I can't remember who was inquiring, but the court's intention was to have this docket call today to get a handle on what we will actually hear tomorrow. I consider tomorrow, Thursday, 1:30 as our motions time because I do have a full docket this morning. So as I also mentioned off the record, I think I received an email with some 23 matters that need to be heard. The court, unless you all are telling me otherwise, is fully intends to have everything heard tomorrow. So unless you're telling me there's a whittling down of those lists, either in that amended notice or the email that I received, those will be heard in person tomorrow in court. So is there?
Your Honor, one question. This is Carlos Rincon.
Yes, sir.
Would it help you if you were to receive paper copies of what is going to be heard, like in binders, or is electronic versions adequate? Some courts like paper copies. It's up to you. I don't want to crowd you with a bunch of notebooks.
So I hate to burn paper, but you know, our budget for supplies is crazy. So that's why I was asking you, you know, commissioners have zeroed out our budgets. So that's why I was asking initially, I think with the exhibits, but I'm good with the e-copies. On the email that had those 23 motions, there were e-copies. I'm fine with that. I will request if I need hard copies from you all. But I think whoever was asking about the exhibits, I think I asked for hard copies of those. So.
All right, Judge. Thank you.
What else? So I'm not hearing any whittling down of the lists.
Well, Your Honor, let me just, I think I can whittle down at least one thing, but the court has referenced a notice of hearing that listed 23 different items.
So no, it's an email. So I have the amended notice of requested hearing dated July 14th, and that has 12 items listed. I believe, Mr. Rincon, you filed that. I initially saw that, but let me go back because I think this email came in this morning, if I can access my email. Let me find it. Okay, this is an email from your office, Mr. Villanueva, saying attached, please find the following documents set for hearing today. So this was sent this morning at 9:05, and it lists 23 matters to include motions in limine, objections, motion to exclude. I mean, came from your office, Mr. Villanueva. So, and there I have all of those pleadings attached electronically. So I'm good with that.
Okay. Yeah. Okay. So those are 23 documents that I think go along with the matters that were set for hearing. So what I can do for the court is, yes, those are 23 documents. Mr. Rincon's office filed a notice of hearing indicating, I believe, 12 different matters that he wanted heard. And then I filed also notice of hearing just on 3 other ones that weren't included. Okay. What I can represent to the court is that on Mr. Rincon's amended notice of hearing, for number 10, he'd set for hearing a plaintiff's motion to exclude Mr. Ashby, who is an expert. I can represent to the court and to Mr. Rincon that we will not pursue that. We will just rely on our cross-examination of him. So for that issue, we could go ahead and mark that one off the docket. But for the other, I guess, 11 issues that were raised in that amended notice of hearing, we can proceed on those.
So, and I may have misspoken because because I'm getting these emails while we're handling the docket. I'd not cross-checked or looked very closely. I just saw 23 and I said, yeah, that sounds like 1:30 tomorrow. But I hear what you're saying, Mr. Villanueva. So I apologize if I'm like making it seem like it's more than it is. I just am not having time to kind of double check. So what else?
Your Honor, just a housekeeping matter on my end. So I had explained to counsel, Mr. Lyles, that Ron Ashby, my DOT expert, is he has a travel conflict. It may not surface as an issue in the trial, but if it does, I was going to request leave to present him via teleconference. I've done it in other trials in El Paso. But that would be a last resort. My preference obviously is to get him here in person, but I don't know exactly when the plaintiff's case would end. So I just wanted to alert the court. I don't know how Your Honor feels about teleconference witnesses, but I do it all the time. It seems to work.
What is plaintiff's position on that? I don't love it, but I don't have a problem with it, Mr. Rincon, because if that's the best we can do, as you say, as a last resort. But let me hear from either Mr. Villanueva or Mr. Lyles. Are you all okay with teleconference testimony?
Well, Your Honor, we've made the steps to bring our experts here live and in trial. So we were the expectation that also Mr. Ashby would be live in trial. And then also, as I just said, we're not going to pursue the motion to exclude him. We're going to rely on cross-examination, which would include documents and things like that, other exhibits. So with that, and then I'll defer to Mr. Lyles. I don't know if he wants to say something as well, but that's currently my understanding.
Yes, sir.
Good morning, Judge. We've tried to do this by Zoom in the past, and my experience is it's always difficult. And we've made all accommodations to have our experts there in person and witnesses there in person. And so it would be our preference to not have anybody by Zoom.
Yeah. Mr. Rincon, my biggest concern is always the kind of like the technical end of it, right? It's like just one of those things where, as great as everything will be going, just, the internet will have a glitch, will have, it'll just be that kind of thing. And that's really what brings me, I'm not so concerned with, having remote testimony. It's just the technology sometimes that would be frustrating.
And it may lead to me requesting leave to have him called out of order.
Okay.
Because he's a unique, witness. I think that would work, but it would obviously take into account the plaintiff's position on that. It's an administrative issue. With all the witnesses and moving parts of it, that's the only scheduling issue I've had. And I alerted counsel when I learned about it. But I don't know how to present it with more clarity than I have already, because it may be completely moot, depending on the timing of how and when the plaintiffs rest. But if we need to get Mr. Ashby on the stand in person, I will be asking for leave to call him out of order.
Yes, sir. I understand that.
And we'd be agreeable to discussing that, Judge.
Yeah.
I think I want to try, Mr. Rincon, at all costs not to use Zoom. So we'll just see how we go from there. But thank you for the heads up.
Okay.
Thank you. What else?
Judge, the only question I had is, since I'll be flying in, we start at 1 tomorrow. That's correct?
Yeah, 1:30. 1:30.
Okay.
So just check in with Mr. Nunez, and if you're here early, you need to drop stuff off. I can't think. No, we have a criminal docket in the morning, so we'll be here though.
Thank you, Your Honor.
What else? Okay. So
I'm sorry. I'll just let you know, Your Honor. I don't think with regards to the specific motions to exclude, I don't perceive there to be any further resolutions on that. However, for the motions in limines, like for instance, Landstars has around 80 motion in limine points. I'll just let you know, we'll try to see if we can maybe resolve some of those to help with the time. And then we'll work with them on our motion in limines as well.
okay, that's helpful. Anything else?
No, that's it, Judge.
I'm trying to think if logistically I have anything else for you all. Mr. Nunez, can you think of anything? No? All right.
No, ma'am.
So with that, then I'll see everyone tomorrow at 1:30 and we'll just jump into it. Okay?
Thank you.
All right, Judge.
And did everybody get jury sheets already?
Yes, Your Honor.
Yes, Your Honor.
Wonderful. Okay, cool. That was unexpected. We don't always, I know it doesn't seem super early, but lately we've been getting them very late from jury hall. So, all right, gentlemen, we'll see you all tomorrow.
All right.
Thank you.
Have a
Appreciate
great
it.
day, Judge.
Thank
Thank
you.
you for your time. Bye-bye. All right. So let's get back to, hold on. Walter, you need a break? 5 minutes. Okay. Thank you. We can get off of